And on the last day of Pride 2023, the Republican-appointed justices on the Supreme Court enshrined discrimination against LGBTQ people. In a case deliberately brought to advance conservative interests in a favorable court, and of course it was about a wedding website, it was decided that an evangelical website designer in Colorado would not have to build a website for a same-sex couple because it would violate her First Amendment right by forcing her to say something she didn't believe. But here's the thing. No gay couple actually asked for this evangelical website designer's work. The conservative legal interest groups created out of whole cloth this fever dream that an evangelical wedding website designer would have her rights hypothetically challenged if a hypothetical same-sex couple hypothetically asked for her to design the website for their wedding because she doesn't believe in their constitutional right to marry. Now, it's hard to imagine exactly which part of the wedding website would be so violating. Is it having to type the words Adam and Steve, summer 2023, directions to the venue, chicken, beef, or vegetarian? Like, what exactly is the profession that would so violate her quote unquote sincerely held beliefs about marriage? It seems unlikely that any actual engaged gay couple would seek out this person's services for a custom creation for their love story. What is more concerning is what legal floodgates have been opened by a Supreme Court conservative supermajority. Justice Sonia Sotomayor argued in her dissent, "Today is a sad day in American constitutional law and in the lives of LGBT people." The Supreme Court of the United States declares that a particular kind of business, though open to the public, has a constitutional right to refuse to serve members of a protected class. The court does so for the first time in its history by issuing this new license to discriminate in a case brought by a company that seeks to deny same-sex couples the full and equal enjoyment of its services. The immediate symbolic effect of the decision is to mark gays and lesbians for second-class status. In this way, the decision itself inflicts a kind of stigmatic harm on top of any harm caused by denials of service. The opinion of the court is, quite literally, a notice that reads, "Some services may be denied to same-sex couples." So what's next? That's the ominous question at the end of this Supreme Court term, which just yesterday struck down affirmative action in higher education. It's the feeling that I and people who look like me and were born like me don't have the right to the promise of America as spelled out in our founding documents, our Constitution. That others in America, today the Republican conservatives on the court, will give me what they think I deserve among our cherished ideals. My possibilities are up to them, not up to me. A decade ago, America was advancing. Barack Obama was president. His evolution from the don't ask, don't tell days of the previous Democratic presidency to full-throated support of same-sex marriage complete. The Supreme Court ruling in favor of same-sex marriage, an opinion written by a Republican-appointed justice, Anthony Kennedy, was a 5-4 decision that tracked with public opinion on the issue. Pride 2015 was capped off with the first black president lighting up the White House, a house built by slaves, in full support of LGBTQ Americans like me. That was a symbolic moment that told me in no uncertain terms that America's full promise is mine as much as anyone's. The growling dissents of Justices Roberts, Alito, Scalia, and Thomas would be relegated to the dustbin of history. But today, I feel the way many women have been feeling since last year when this court took away their constitutional right to their bodies. You have no right to anything that others haven't decided you can have. And if you live in a red state run by Republicans, that could be nothing. Too bad. We don't have to wonder what's next because Clarence Thomas told us in his concurrence in the Dobbs decision. Clarence Thomas wrote, "In future cases, we should reconsider all of this court's substantive due process precedents, including Griswold, Lawrence, and Obergefell. because any substantive due process decision is demonstrably erroneous. We have a duty to correct the error established in those precedents. Clarence Thomas wants to correct the error of conception, of letting people love who they want to love, of letting people marry who they want to marry. In Oliver Twist, an orphan dares ask the master for more food at dinner. "Please, sir, can I have some more?" The master was a fat, healthy man, but he turned very pale. He gazed in stupefied astonishment on the small rebel. The assistants were paralyzed with wonder, the boys with fear. "What?" said the master at length in a faint voice. "Please, sir," replied Oliver, "I want some more." And then the master hits him on the head with the ladle. The Roberts Court is the please, sir court, and the rest of us will get whatever rights this court and the far-right forces who put them there decides to dole out to us.